concerning the memorandum of points and authority supporting the vexatious litigant motion prepared by old crazy attorney Briar, license number 330215 in California. This document summaries accounts of the facts and context that are materially misstated, distorted, or omitted in the memorandum of points and authorities. My only brother was diagnosed with liver cancer and repeatedly given a prognosis of approximately 6 months to live. This prognosis was reiterated over the next 6 years as he underwent intensive treatment, including periods on the national transplant list. He ultimately died after multiple hospitalizations. From 2000 forward, I assumed the role of caregiver, patient advocate, coordinator of medical care. I worked in healthcare emergency response, diverted my own career plans to assist him. During much of this period, my brother was effectively homeless, living in his car, garages, or basements, while continuing to work for wealthy real estate owning couple Yehuda Ferris of Chabad of the East Bay, who later became trustee and beneficiary fiduciaries. Despite owning extensive property and living in multi-million-dollar residence, they never offered my brother housing while he was undergoing cancer treatment. My brother's own adult daughters, Catholic Filipinos, ceased contact with them in 2014 after his diagnosis and did not communicate with him again prior to his death. They ignored outreach from treating physicians at UCSF and did not participate in his care. Their absence during his terminal illness was the central emotional and factual reality of his final years. Context is either omitted or reframed in the memorandum in a way that portrays my later actions and statements as harassment rather than concern from abandonment during terminal illness. My golly, I can't get this right. Just forget about it. What does it say here? My presence in the home and COVID-era proceedings. In February 2019, after my brother suffered severe hepatic encephalopathy and nearly died, he regained possession of his only owned home and invited me to move in and assist with care. Lived there continuously from that point onwards. We're going to have to go to part 2. During the COVID pandemic, eviction moratorium were in effect. Nevertheless, the co-owner, my brother's former partner, Nancy Salgado, mother of the children, sought a restraining order and removal. She wasn't living there. I retained counsel and prevailed, with the court explicitly noting the eviction during the pandemic was improper. At that time, attorney William Rogers, who drafted the trust instruments and represented the trustee, contacted me repeatedly, encouraging me to remain in the home and leverage against the co-owner. He initially represented to the probate court that the trust did not want me removed and sought guidance to avoid favoring one beneficiary over another, including my sisters, 2 sisters, who are on my side.